The Chatham County Courthouse stood 3 stories above Bull Street, its columns pale against the live oaks, its second-floor registry room holding 17 cabinets of bound volumes recording every deed, manumission, and probate matter filed in Savannah since 1790. In the spring of 1927, during renovations to install electric lighting, a construction foreman discovered a leather portfolio wedged behind the bottom drawer of the 6th cabinet, wrapped in oilcloth and tied with cotton string that crumbled at first touch. Inside lay 23 pages written in 2 distinct hands, one the practice script of a legal clerk, the other cramped and uneven, each page headed with a date between October 1858 and February 1859. The portfolio contained no filing notation, no docket number, no stamp of receipt. Every page bore the same header: in the matter of Samuel Croft, minor versus his father, petition for recognition. No such case appeared in any surviving index from that year. The first page outlined a claim that no Georgia court had jurisdiction to hear under the laws then governing persons of mixed ancestry. A boy of 12 years, described in the petition as having been born in the household of Judge Thaddeus Croft of Oglethorpe Ward, sought recognition as legitimate issue and requested removal from the county's registry of free persons of color, where his name had been entered at birth under the surname of his mother. A woman listed only as Celia, spinster, lately of this parish. The petition argued that the boy's parentage entitled him to inherit property and standing, that his education and baptism had been conducted as befitted a white child of respectable lineage, and that his continued classification inflicted harm, both legal and moral. The second hand, appearing in marginal notes and appended testimony, recorded observations of household routines, visitors to the Croft residence on East Broad Street, and the specific wording of conversations held in the judge's library on Tuesday and Friday afternoons, when the house staff served tea and the judge received colleagues. Whoever wrote those notes had access to spaces usually closed to witnesses. Savannah in 1858 held 22,000 souls, half enslaved, a quarter free persons of color working as carpenters, seamstresses, carters, and stevedores along the wharves where cotton bales moved from interior plantations to ships bound for Liverpool and Le Havre. The city's wealth rested on the labor of those who could not testify in court, own property beyond a narrow exemption, or move between wards without a passbook signed by a white sponsor. Judge Croft presided over the Superior Court, hearing cases involving property disputes, wills, and criminal matters that exceeded the jurisdiction of the municipal recorder. His household on East Broad occupied a 3-story townhouse with ironwork balconies and a walled garden where oleander and crepe myrtle screened the kitchen building from the street. The house employed 7 enslaved workers: a cook, a laundress, 2 housemaids, a coachman, a yardman, and a boy who ran errands and served at table during evening gatherings when merchants and attorneys arrived to discuss rice prices and railroad bonds. The judge's wife had died in 1849, leaving no surviving children after 3 stillbirths and a fever that took their infant daughter in 1847. The household ran with the efficiency of a well-managed concern. Meals served at precise hours, linens changed on Mondays, accounts settled on the 1st of each month. The boy Samuel appeared in parish baptism records from January 1846, listed with his mother's surname only, baptized privately rather than during Sunday service. He wore clothes cut from good broadcloth, attended lessons with a tutor who came Wednesdays and Saturdays, and ate meals in the kitchen building rather than the main house. Neighbors remarked on the judge's unusual attention to the child's education, the Latin primers visible through the kitchen window, the penmanship exercises left to dry on the work table where the cook rolled pastry. Before we carry on, please hit the subscribe button to make my day and let me know where you're watching from in the comments. The matter came to public notice in October 1858, when a clerk at the county registry office refused to issue Samuel a new passbook after the boy's 12th birthday, the age at which free persons of color were required to renew documentation annually. The clerk, a man named Elias Finch who had served the office for 14 years, informed the boy that his current passbook listed an erroneous surname, and that correction would require testimony from the judge himself, appearing before the registry commission, to attest to the boy's parentage under oath. The boy returned to the house on East Broad and delivered this information to the judge during the afternoon hour, when the household paused between dinner service and evening preparations. What passed between them in the library that day went unrecorded in any formal document, but the cook later told the laundress that the judge had struck the mantel with his fist hard enough to crack the marble facing, that raised voices carried to the kitchen, and that the boy emerged from the library with instructions to remain within the household until the matter could be properly addressed through legal channels. The petition that appeared at the courthouse 3 weeks later bore the signature of a white attorney named Augustus Helm, known for representing merchants in contract disputes but never previously involved in matters concerning enslaved or free colored persons. The filing cost $2, paid in silver coins that the clerk counted twice before recording the docket entry in the day book, then immediately crossing it out and refunding the payment with instructions that no such petition could be entertained under Georgia law as it then stood. Helm argued that the boy's baptism and education demonstrated acknowledgement of paternity, that the judge's provision for the child exceeded what any master might grant a servant's offspring, and that denying recognition inflicted irreparable harm on a minor who had committed no offense against law or morals. The clerk pointed to statutes forbidding legitimization of children born to mothers of African descent, regardless of the father's race or intentions. Helm left the courthouse with the unprocessed petition and filed a second version the following day, this time omitting direct reference to the boy's maternal ancestry and arguing instead on grounds of property interest and testamentary capacity. The second filing prompted a response from the Registry Commission, a body of 5 men responsible for maintaining county records and resolving disputes over documentation. The commission met in a room above the tax assessor's office, their sessions closed to public observation, their decisions recorded in a separate ledger kept under lock in the commission chairman's desk. The chairman, a cotton factor named Josiah Mercer, had known Judge Croft for 30 years, served alongside him on the vestry of Christ Church, and dined at the East Broad House on numerous occasions when rice prices or railroad investments required discussion among men whose capital shaped the city's commercial direction. Mercer scheduled a hearing for November 12, 1858, requiring the judge's attendance but not the boy's, a procedural choice that ensured Samuel's testimony would not enter the official record. The hearing lasted 90 minutes, conducted in the commission room with only the 5 commissioners, the judge, and Attorney Helm present. No transcript survives in any courthouse archive, but the commission's ruling, issued 4 days later, denied the petition on grounds that acknowledgement of paternity could not alter legal status derived from maternal ancestry, that Georgia law provided no mechanism for reclassification absent legislative act, and that the boy's current designation as free person of color reflected accurate application of existing statutes. The ruling recommended that the judge continue providing for Samuel's material welfare within lawful bounds, suggested that a properly executed will could ensure the boy's security after the judge's death, and noted that several respectable free-colored families in Savannah maintained comfortable circumstances through skilled trades and prudent management. The commission filed the ruling in its private ledger, but declined to forward any record to the county court, treating the matter as administrative rather than judicial. The boy's response emerged not through legal channels but through the methodical documentation visible in the margins and appended pages discovered in 1927. Someone with access to the household began recording the judge's movements, the names of visitors, the specific times when the judge left for court sessions and returned in the afternoon. The notes detailed which rooms the judge occupied at which hours, when servants were dismissed from the main house, and the location of keys to the library and the judge's upstairs study. The handwriting suggested education, familiarity with legal terminology, and close observation of routines that most household staff would consider unremarkable. Entries described the judge's habit of taking laudanum for headaches each Thursday evening, the precise dosage measured into a glass of port wine, the hour when he retired to his chamber and dismissed the housemaid who turned down his bed. The notes also recorded conversations held in the library when merchants and attorneys gathered to discuss matters of business and politics. On December 3, 1858, the judge entertained 6 men, including Commission Chairman Mercer, and 2 attorneys who practiced before the Superior Court. The conversation, transcribed in the margin notes with remarkable specificity, addressed concerns about Northern abolition societies sending agents into Georgia to encourage escapes and document conditions on plantations for propaganda purposes. One attorney worried aloud about legal challenges to property claims, the possibility that Northern courts might refuse to recognize Southern ownership of persons who reached free territory, the need for vigilance among households to prevent servants from acquiring literacy or communicating with outsiders who might encourage defiance. The judge, according to the notes, expressed confidence that Georgia's legal structures would withstand external pressure, that courts existed to protect property interests recognized under law, and that sentiment must not override established principle. He poured a second round of port wine and proposed a toast to the stability that separated civilized commerce from the chaos of societies that permitted social leveling. The preparation phase, if such a term fits the pattern visible in the surviving documents, occurred between December 1858 and late January 1859. The margin notes recorded an inventory of documents stored in the judge's study. A will dated 1856 leaving the household and its contents to a nephew in Charleston. Account books detailing expenditures for household staff, including payments for Samuel's tutor and clothing. Correspondence with cotton factors regarding investments in railroad shares and warehouse leases. The notes described the location of these documents in a rosewood cabinet beside the judge's desk, the type of lock securing the cabinet, and the fact that a duplicate key hung on a peg in the kitchen building where the cook kept implements for polishing silver. Additional entries documented the judge's schedule of court appearances, his habit of attending vestry meetings at Christ Church on the first Monday of each month, and the evening hours when he worked alone in the library preparing legal opinions for upcoming cases. Entries from mid-January described a shift in household atmosphere. The cook received instructions to prepare meals for evening gatherings more frequently, as if the judge sought to demonstrate normalcy through social routine. Samuel appeared less often in the kitchen building during daylight hours, his lessons apparently suspended or conducted privately. The laundress mentioned to the coachman that the boy had been observed in the alley behind the house, speaking with a free-colored carpenter, who maintained a shop 2 blocks distant on Broughton Street, a man known for his literacy and his habit of keeping account books that recorded not just carpentry commissions but births, baptisms, and burials among Savannah's free-colored community. The carpenter's shop contained a strong box where he stored documents for families who trusted him with papers that might otherwise be lost or seized during sheriff's sweeps for verification of status. The set-piece moment arrived not through dramatic confrontation, but through an absence that altered the pattern of official records. On January 28, 1859, Judge Croft presided over a full docket of cases in the Superior Court, heard testimony in a property dispute between 2 merchant families, and issued a ruling on a will contest that had consumed 3 days of argument over whether a deceased planter's bequest to a Free Baptist congregation violated the testator's family obligations. The judge returned home at his usual hour, took his Thursday evening dose of laudanum mixed with port, and retired to his chamber. The housemaid who brought morning tea found him unconscious at 8 the following morning, his breathing shallow, the empty laudanum bottle on the bedside table alongside a half-finished glass of wine. A physician summoned from Oglethorpe Ward attempted treatment with emetics and cold compresses, but the judge never regained consciousness. He died at noon on January 29th, with the household staff gathered outside his chamber door, and the nephew from Charleston not yet notified by telegram. The death prompted immediate attention from the probate court, which appointed an executor to inventory the household and identify creditors before distributing assets according to the 1856 will. The executor, an attorney named Porter Gladwell, who had occasionally practiced before Judge Croft's court, arrived at the East Broad House on February 1st with instructions to secure all documents and valuables pending formal appraisal. He found the library in order, the study cabinet unlocked, and several documents missing from locations described in an inventory the judge had prepared the previous year. The missing items included the account books detailing expenditures for Samuel's education, correspondence with the carpenter on Broughton Street concerning construction of a desk for the boys' lessons, and a sealed letter addressed to the Registry Commission but never sent. Its existence noted in the judge's private memoranda but not found among his papers. The executor questioned the household staff, particularly the cook who held keys to various storage areas, but received only vague responses suggesting confusion about the judge's filing system. The nephew arrived from Charleston on February 5th and immediately petitioned the probate court to expedite settlement, arguing that prolonged inventory would interfere with the efficient transfer of property. The court agreed, and by February 20th, the household had been appraised, the enslaved workers assigned to the nephew's ownership, and the house prepared for sale to satisfy minor debts. Samuel appeared in the final inventory as property transferred to the nephew's ownership, his name listed alongside the cook and housemaids, his value assessed at $400 reflecting his youth and training. The carpenter on Broughton Street received a visit from the sheriff's office 3 days after the inventory was completed. His shop searched for documents that might bear on the estate settlement. His strongbox opened and its contents examined for evidence of theft or improper conveyance of the judge's property. The sheriff found nothing actionable, only baptism certificates, manumission papers, and apprenticeship contracts for families who lacked other secure storage. The carpenter produced a receipt dated January 27, 1859, documenting payment of $6 for construction of a writing desk, signed by the judge's cook acting as household agent. The sheriff noted the transaction in his report but pursued no further inquiry. The nephew departed for Charleston in early March with ownership papers for the household staff, leaving instructions for the sale of the house and its furnishings. Samuel's name appeared on the coasting manifest when the nephew's household goods were transported by steamboat to South Carolina, listed among servants and furniture with no indication of unusual circumstances. The cover-up required no conspiracy, only the ordinary operation of institutions designed to protect property interests and social hierarchies. The probate court filed its report according to standard procedure. The Registry Commission made no reference to the November hearing in any public document, and the attorney Helm accepted a commission to handle commercial litigation for a firm in Augusta, relocating his practice before the summer heat arrived. The missing documents from the judge's study generated no investigation beyond the executor's cursory questions to household staff, the assumption being that the judge had destroyed personal correspondence before his death or misfiled items that held no bearing on estate settlement. The sealed letter to the Registry Commission, mentioned in the judge's memoranda but never located, might have contained a revised petition or instructions for future action, but its absence removed any potential challenge to the smooth transfer of property to the Charleston nephew. The institutions involved required no explicit coordination to ensure silence. The probate court existed to transfer property efficiently, not to interrogate the moral dimensions of ownership. The Registry Commission maintained records that preserved social order, documenting status rather than questioning the justice of classifications that determined who could testify, inherit, or move freely through public spaces. The church vestry where Judge Croft had served accepted a memorial donation from the Charleston nephew and commissioned a marble plaque honoring the judge's service to Christ Church, his 30 years on the Superior Court bench, and his reputation for measured judgment in matters of law and commerce. The plaque made no reference to household arrangements or petitions declined by bureaucratic procedure. The dispersal of persons who might have testified to household routines followed patterns typical of estate settlements. The cook and housemaids remained with the nephew in Charleston, their knowledge of the East Broad House becoming irrelevant in a new setting where different routines and different hierarchies governed daily life. The carpenter on Broughton Street continued his trade, his strongbox accumulating more documents as families sought secure storage for papers that represented the fragile margin between free status and vulnerability to seizure or sale. He never spoke publicly about conversations with Samuel or documents that might have passed through his shop during the winter of 1858-59, his silence reflecting the practical wisdom of men who navigated systems designed to contain and control their communities. The unofficial record, the one that survived through craft and quiet resistance rather than official filing, continued through methods that left minimal trace. Free-colored churches in Savannah began maintaining more detailed baptism records during the 1860s, noting parentage with unusual specificity and recording private ceremonies that occurred outside regular Sunday services. Seamstresses and laundresses developed patterns of stitching names into quilts and garments, creating textile archives that documented births, deaths, and connections that appeared nowhere in courthouse ledgers. The carpenter's strongbox, passed to his daughter when he died in 1871, eventually held documents spanning 50 years, a shadow registry that recorded lives and relationships that official systems refused to acknowledge or protect. These methods predated the judge's case and continued long after, part of a broader pattern of creating durable memory in societies that denied legal personhood to those whose labor sustained the economy. Trials following the judge's death proceeded according to the forms that governed such matters in antebellum Georgia. No criminal investigation examined the circumstances of his laudanum overdose, accidental poisoning being sufficiently common among persons who used opiates for chronic pain that physicians and coroners rarely pursued inquiry beyond establishing cause of death. No civil action challenged the probate settlement, the nephew's ownership of the enslaved household staff receiving recognition in both Georgia and South Carolina courts without controversy. Attorney Helms' relocation to Augusta removed the only legal advocate who had attempted to navigate the impossible terrain between acknowledgement of paternity and the statutes governing racial classification. The Registry Commission continued its work of maintaining county records, processing passbook renewals, and filing manumission papers when masters chose to free enslaved persons according to procedures that required posted bond and testimony about the freed person's character and capacity for self-support. The truth about Samuel's fate survived in fragments, the kind of evidence that required assembling across different archives and recognizing patterns in absence and silence. The Charleston nephew's household records, preserved in a collection donated to the South Carolina Historical Society in 1903, listed a servant named Samuel, who worked as a house carpenter and maintained tools for repairs and maintenance. The same records showed that this Samuel received manumission in 1867, 2 years after the 13th Amendment rendered such documents symbolically rather than legally significant. The manumission paper noted no surname, no parentage, and no explanation for the timing or motivation of the act. A city directory for Charleston from 1870 listed a carpenter named Samuel Croft operating a shop on Meeting Street, his race designated as colored, his business described as specializing in furniture repair and custom joinery. Whether this Samuel was the boy from the East Broad House in Savannah, whether he chose to adopt his father's surname after emancipation, and whether the documents hidden behind the courthouse cabinet represented his own preparation of evidence or assistance from others who recognized the importance of creating a record that might survive official suppression. These questions admit no definitive answer from the surviving materials. What remains clear is that someone with access to the judge's household, someone with sufficient education to transcribe legal language and detailed knowledge of the routines that governed property and status in antebellum Savannah, created a documentary record that contradicted the official silence. The portfolio's survival behind a courthouse cabinet, wrapped carefully and hidden where renovations might eventually reveal it, suggests intentional preservation rather than accidental loss. The aftermath continued in the quiet adjustments that marked how communities responded to institutional failure or complicity. Savannah's free-colored community developed more elaborate systems for documenting births and maintaining records that could prove identity and relationships when official registries refused recognition or provided minimal information designed to facilitate control rather than protect rights. Churches began transcribing baptism records into multiple ledgers, storing copies in different locations to prevent loss if one record was seized or destroyed during periods of heightened surveillance. Families used photographs, when that technology became accessible in the 1860s, to create visual documentation of kinship, the images serving as evidence that written records might not provide. These practices reflected accumulated knowledge about the unreliability of official systems and the necessity of creating parallel archives that could serve needs the state refused to acknowledge. The judicial system's response to cases that challenged racial classification remained consistent through the antebellum period and continued in modified form after the Civil War. Courts declined jurisdiction over petitions that sought to reclassify individuals based on parentage, treating such matters as settled by maternal ancestry, regardless of evidence about paternal acknowledgement or provision. Statutes governing legitimization explicitly excluded children born to mothers of African descent, creating a legal framework that made paternity irrelevant for purposes of inheritance, standing, or social recognition. This framework persisted despite occasional attempts by attorneys to argue for exceptions based on particular circumstances, the pattern of rejection becoming so routine that few lawyers accepted such cases after the 1850s. The Registry Commission's decision in Samuel's case represented ordinary application of this framework rather than unusual cruelty. The institutional machinery functioning as designed to preserve hierarchies that structured economic and social relations. The physical spaces where these events occurred retained their own forms of memory, visible to those who knew how to read architectural and spatial evidence. The East Broad House sold to a cotton factor in 1859, its interior renovated to suit the new owner's preferences. But the kitchen building remained largely unchanged until demolition in 1891 to make space for a commercial warehouse. Photographs from the 1880s show the kitchen's exterior, its windows still arranged in the pattern that would have allowed observation of the main house's library windows. The door positioned to facilitate movement between the two structures while maintaining the spatial separation that marked the division between formal household spaces and service areas. The courthouse registry room where the commission conducted its hearing remained in use until the 1930s, its layout preserved in architectural drawings that show the commission's deliberation chamber accessible only through the tax assessor's office, designed to ensure privacy for proceedings that shaped individual fates while generating no public record. The legacy survived in changed practices that rarely acknowledged their origins. Churches in Savannah's free-colored community maintained unusually detailed records compared to counterparts in other southern cities, their ledgers noting parentage, baptism dates, and witnesses with specificity that exceeded legal requirements and suggested institutional memory about the importance of creating durable documentation. Attorneys in Savannah developed a reputation for declining cases that involved challenges to racial classification, the professional consensus being that such litigation consumed resources without producing favorable outcomes and exposed clients to retaliation or heightened scrutiny from authorities. The Registry Commission quietly adjusted its procedures during the 1860s to require more extensive documentation for passbook renewals. The change ostensibly aimed at preventing fraud, but effectively increasing the bureaucratic burden on free persons of color and expanding opportunities for arbitrary denial or delay. The personal costs of these institutional patterns rarely appeared in official records but survived in family stories, coded references, and the practical wisdom passed between generations about navigating systems designed to constrain and control. Free-colored families in Savannah learned to maintain multiple copies of crucial documents, to secure witnesses who could testify to births and relationships, and to cultivate relationships with white sponsors who might intervene when bureaucratic procedures threatened stable arrangements. They learned that acknowledgement by white fathers provided no legal protection, that education and property ownership offered limited security in systems that could reclassify or seize assets based on ancestry rather than conduct, and that survival required building parallel structures of support and documentation that official institutions refused to provide. The craft of resistance, if that phrase captures the methodical work visible in the hidden documents, consisted largely of creating durable records and securing them in spaces that might survive institutional hostility or indifference. The carpenter's strongbox, the church ledgers with their detailed notations, the quilts with names stitched into seams, and the portfolio hidden behind courthouse cabinets. These represented parallel archives created by people who understood that official records existed to serve interests that often conflicted with their own survival and security. These archives required physical skill, the carpentry that created secure boxes, the needlework that embedded information in textiles, and institutional knowledge, understanding which documents proved essential, which white sponsors might be trusted, which storage locations offered reasonable security against periodic sweeps and seizures. The notes transcribed in the portfolio margins, with their precise documentation of the judge's routines and conversations, reflected this accumulated knowledge. Whoever recorded those observations understood that credibility required specificity, that future readers would need to assess whether claims rested on plausible access and reliable memory. The notes documented times, dates, names, and locations with the attention to detail that characterized legal testimony, creating a record that could serve as evidence even though no court would admit it as such. The care taken to preserve these notes, wrapping them in oilcloth and hiding them where renovation might eventually reveal them, suggested understanding that immediate justice might be impossible, but that future recognition remained a legitimate goal worthy of methodical effort. The epilogue image, discovered during courthouse renovations in 1927, captures the paradox that defines these histories. The portfolio sat behind courthouse cabinets for 68 years, its contents unread by anyone with power to act on the claims it documented. The construction foreman who found it brought the pages to the county clerk, who examined them briefly and filed them in the historical archives without attempting to verify their accuracy or trace their implications. The pages entered the archive as curiosities rather than evidence, their legal claims moot after the 13th and 14th Amendments had rendered antebellum classifications obsolete. Yet their survival represented a kind of victory, the creation of a record that contradicted official silence and documented institutional complicity in the perpetuation of injustice. The registry room where the foreman made his discovery retained marks of its history visible to those who examined the space carefully. The cabinet that concealed the portfolio showed wear patterns suggesting it had been moved slightly during its years of service, perhaps shifted to allow a thin package to slip behind its bottom drawer. The floorboards near the cabinet bore scuff marks that might indicate someone kneeling to retrieve or hide objects in that location. The window overlooking Bull Street remained in its original position, offering a view of Christchurch's steeple and the live oaks that lined the street where Judge Croft had walked to court sessions for 30 years. These physical traces offered no definitive answers but invited speculation about how the portfolio reached its hiding place, who placed it there, and whether they believed it would eventually surface. The courthouse itself became a monument of sorts, its architecture and surviving records documenting the institutional structures that governed lives and determined fates throughout the antebellum South. Visitors to the building in later decades could examine the Commission's private ledger with its ruling on Samuel's petition, the probate files documenting Judge Croft's estate settlement, and the hidden portfolio with its contradictory account. The juxtaposition of official record and unofficial testimony illustrated the gap between legal proceedings and lived experience, between the claims institutions made about justice and order, and the realities of systems designed to protect property interests, while denying personhood to those whose labor created the wealth that sustained those institutions. The singing changed in Savannah's churches during the decades after the war, the old hymns acquiring new verses that spoke of deliverance and recognition, of names restored and families reunited, of justice deferred but not forgotten. The Free Baptist congregation where the judge's will contest had directed a bequest continued holding services in the same building on Green Square. Its membership, including descendants of free-colored families who had navigated the antebellum system with its passbooks and registry requirements, and white sponsors whose signatures granted permission for movement between wards. The hymns sung there on Sunday mornings carried harmonies that predated the war, musical patterns preserved by people who understood that some forms of memory required sound rather than writing, voices rather than documents, shared performance rather than individual testimony. The carpenter's shop on Broughton Street, where Samuel had been observed speaking with the shopkeeper during the winter of 1858-59, operated until 1889, when the owner's daughter sold the business and donated the strongbox of documents to the First African Baptist Church for safekeeping. The church maintained the collection in its archive, a repository of papers documenting lives that appeared only marginally in official records, if at all. Researchers examining those materials in later years found baptism certificates, apprenticeship contracts, and manumission papers covering 5 decades, each document representing a negotiation with systems that grudgingly recognized free status while imposing constant surveillance and arbitrary restrictions. Among these papers appeared no direct reference to Samuel Croft or the petition filed in 1858, but the patterns they documented, the careful preservation of evidence, the reliance on parallel institutions, the recognition that official records could not be trusted to tell full truths, reflected the accumulated wisdom of communities that created their own archives when state structures refused to provide justice or recognition. What detail from this case lingers in your mind? The portrait hidden behind the courthouse cabinet, the commission's quiet denial, or the names stitched into quilts when ledgers refused to record them? Let me know your state in the comments, hit subscribe, and turn on notifications so you never miss the next investigation.